I'm really delighted to be welcoming you here today at CCLS. It's a really great pleasure, and it's also honestly a tremendous privilege because this is such a wonderful workshop and it's such an amazing group of people that Bankole has assembled. I take no credit. And my name is Johanna Gibson. I'm the Herchel Smith Professor here at the Centre for Commercial Law Studies at Queen Mary University of London. And I'm welcoming you also on behalf of the Queen Mary Intellectual Property Research Institute that's collaborating with Bankole and his firm to bring this amazing event to you. It's really such a privilege for me to be participating in this. We've had a wonderful lead up to this as well with a fantastic discussion the other day. And it's, as I said, such an incredible lineup of speakers. So I think it's truly a treat for us to be together to address and consider some of the issues we're going to look at today. But my very great thanks to Bankole for the opportunity to collaborate on this event. When he contacted me and said, I really want to do something during Inter. What do you think? Here's the date. And so when Bankole says that to you, you go, yes, we're doing it. All right, pull out all the stops. And that's really what made today possible, that tremendous energy and also that wonderful friendship and collaboration across great distances. And of course, Bankole is one of our very distinguished alumni, so it's really special to have him back. It's always a pleasure to welcome you back to CCLS. Now, CCLS itself was established 46 years ago. It's one of the biggest commercial law programs in the world. I dare say it might actually be the biggest, but as you know, as in any PhD, you're never the first, you're never the biggest, you're possibly one of. But we all know what that means. And it was certainly one of the first. And it's really the foresight of Sir Roy Good all those years ago when he said, you know, we need somewhere for a substantive and considered approach to international comparative commercial law. This isn't happening anywhere. It's not happening in the law schools. So we're going to make it happen. And it's really incredible now to see 46 years later, there's literally thousands, tens of thousands of alumni from CCLS all around the world, including Bankole. And so genuinely, CCLS has had this impact all over the world through that alumni network. And today it's, of course, internationally recognized as one of, and you know what that means, the leading centers for research and education in commercial law. But it's not only at the forefront of commercial law education and research in the UK, it genuinely paved the way. And even with recent developments, we're still showing, and we're all the time, direction commercial law education and research needs to take. Just last year, we introduced the UK's very first and still the only LLM in fashion law. We are in the process of proposing and putting through for 2027 an LLM in film and performing arts law. So we're looking at these directions that practice is taking, that research is taking, and really working with our students as well in developing the discipline and shaping new disciplines. So it's always a great pleasure to be here as one of the faculty as well, because you really do get to explore what you love. And today's event, of course, is no exception. It is genuinely in the spirit of CCLS and the spirit in which it was established 46 years ago. Today's event is both timely and critical, as I'm sure all of this audience knows. In Addis Ababa in February this year, at the 39th Ordinary Session of the Assembly of Heads of State and Government of the African Union, the Assembly adopted the 8 annexes to the Protocol on Intellectual Property Rights. And this, of course, under the African Continent Free Trade Area. And of course, this includes the Annex on marks, but also other, across the different rights, but also different areas of intellectual property related to intellectual property, such as traditional knowledge and cultural expressions, among other intellectual property rights and topics. Now, this is towards creating a harmonized intellectual property environment, and with all the promise that might go with that, such as procedural efficiency, certainty for local industry, and also for foreign direct investment. And potentially, for those reasons, a more predictable and rational trade environment, to the extent to which economics is ever rational, but that's a different debate. But this development in February is also significant for a number of reasons that go far beyond concerns with procedural efficiency, because it's potentially a development towards a unified African market in the very widest sense. And this raises both opportunities and challenges, some of which we will be considering today in the context of trademark prosecution and enforcement. As an area of law, trademarks are fascinating for the ways in which they communicate commercial identities, and at the same time for the ways in which they interact with cultural identity, with cultural participation and cultural heritage. And this is why today is such a tremendous opportunity. We're gathering together really seasoned experts across the African continent. And so it is with this that I am very delighted to say that we are being treated to a keynote by Dr. Oduwole, who is the Honourable Minister, Federal Ministry of Industry, Trade and Investment of the Federal Republic of Nigeria. And this is important because we have a high-level discussion today. So we have members from across practice, across industry, across policy making. Prior to her current role, Dr. Oduwole served as the special advisor to the President Bola Ahmed Tinubu on the Presidential Enabling Business Environment Council and Investment from October 23 to October 24. Under the Buhari administration, she served first as the Senior Special Assistant to the President on Industry, Trade and Investment, and subsequently as the Special Advisor to the President on Ease of Doing Business from 2015 to May 2023, so a very distinguished period of time. Dr. Oduwole and her team at the PEBEC Secretariat successfully delivered over 200 verifiable reforms across various arms and levels of government. During her time in public service, Dr. Oduwole has worked on various specialized reform committees in the federal government, such as the African Continent Free Trade Area Implementation Committee and the Tax Policy Reform Committee. And she has played a key role in the conceptualization and establishment of the Nigerian Office of Trade Negotiations. And this is very significant to have this kind of expertise today, because obviously a lot of what we are discussing today are questions of trade and the trade environment. She chaired the technical working team on legislative imperatives for the implementation of the National Development Plan 2021 to 2025. And she's recognized as one of Nigeria's leading reformers. She was awarded the national honor of Member of the Order of the Federal Republic in May 2023 for her contributions to national development. And in 2024, the most influential people of African descent awarded her a Hall of Fame honor for her decade-long work on Nigeria's business climate reforms. She is a policy entrepreneur of some repute, quite clearly. She was appointed as a senior fellow at the Mosavar Rahmani Center for Business and Government, Harvard Kennedy School, and as a governance advisor to the Massachusetts Institute of Technology Governance Lab in 2022 for her innovation in governance. And this is the kind of thinking that we are really grappling with today, looking at these governance questions, but innovation towards achieving the kinds of aims that are at least anticipated by the kind of action that we're seeing recently. And so I'm very delighted that she will be here to talk to us. But she's also coming with a very strong economic focus and a very clear expertise in trade. She's previously served on the board of EcoBank Nigeria, and she's worked in investment and corporate banking at FCMB and GT Bank. Now, since 2015, Dr. Oduwole has been loaned to the federal government of Nigeria from the Faculty of Law, University of Lagos, Nigeria. And at Lagos, she researches and teaches international economic law. She holds an LLB from the University of Lagos an LLM from Cambridge University in the United Kingdom, and a JCM and a JSD from Stanford Law School, USA. And she's also called to the Nigerian bar. So she brings this enviable mix of policy experience, academic expertise, and professional practice to the questions that we have here before us today. So please join me if we are hopefully managing to, she will be joining us online, and hopefully this will work.
I'm here.
Oh, welcome. So please join me in welcoming our keynote speaker, Dr. Jumoke Oduwole. Now, Dr. Oduwole, I will stop sharing our screen so that you will be able to take over with your presentation. Okay, I don't know why.
Okay. Thank you very much, and a very warm welcome to everyone. Good morning, distinguished panelists, global IP practitioners, ladies and gentlemen. I want to start by thanking the organizers, Sodipo and Co., and Queen Mary University, and most especially Professor Bankole Sodipo, Senior Advocate of Nigeria, for the invitation to speak at this event dealing with trademark prosecution and enforcement challenges in Africa. First of all, let's start with the data that frames this discussion. According to the OECD and EU IPO's Mapping Global Trade in Fakes 2025, global trade in counterfeit goods reached approximately $467 billion in 2021, representing 2.3% of total global imports. For the European Union, this rises to 4.7%, valued at USD 117 billion. In the UK, it stands at 1.5% of imports, with an estimated 20,000 job losses. In the United States, where brands bear a significant share of the burden, counterfeit seizures nearly doubled between fiscal years 2023 and 2024. Now, for Africa, there is no equivalent continent-wide figure, not because the problem is smaller, but because the data systems to measure it are not yet sufficiently developed. What we do know is that 42% of all detected cases of substandard or falsified pharmaceuticals globally occur in Africa. And the absence of a reliable number is in itself part of the challenge. So systems that cannot measure losses cannot effectively respond to them. Trademark systems ultimately are not judged by the strength of their statutes, but by their outcomes, how quickly rights are secured, how predictably they are defended, and how effectively they are enforced. So, demystifying the landscape. Africa's trademark landscape operates through three distinct registration frameworks. The African Regional Intellectual Property Organization, established in 1976, covers 22 predominantly Anglophone states. Under the Banjul Protocol, a single application can designate multiple countries. However, enforcement remains dependent on national laws, and only a subset of member states have fully domesticated the protocol. This creates a persistent gap between registration and enforceability. This gap between ascension and domestication is one of the continent's most persistent and structural problems in trademark law. It is worth noting that as at 1st of March 2026, ARIPO implemented one of its most substantial reforms to the Banjul Protocol, introducing a streamlined structure, formal recognition of an ARIPO mark, reduced examination timelines, and stricter opposition periods. A development this practitioner audience should be tracking closely. Now, the organization, well, it's in French. Let me just say the African Intellectual Property Organization, operating under the Banjul Agreement, covers 17 predominantly Francophone member states and provides an automatic regional effect. A single registration is valid across all member states. The structural advantage is clear, but enforcement still depends on national judicial capacity. The challenges, as in ARIPO, is that enforcement remains a national level exercise in courts of varying IP capacity. The Madrid system. The Madrid system, administered by WIPO, is the global route for multicultural, multi-country filing through a single application. But only 24 African jurisdictions are Madrid members, meaning significant portions of the continent still require country-by-country filing strategies. Nigeria operates a standalone national system outside both ARIPO and AOPI, governed by the Trademarks Act. Now, the continental picture. The prosecution and enforcement challenges across the continent are therefore real, but they are not uniform. Global data from WIPO indicates that approximately 15.2 million trademark class count applications were filed worldwide in 2024, with Asia accounting for 65% of that total. Africa's share remains comparatively small, but the trajectory is instructive. Morocco recorded over 29,000 filings, South Africa over 28,000, while Nigeria recorded 243. That figure is not a reflection of Nigeria's engineering capacity, which is well established, but rather a reflection of what happens when registration systems are slow, uncertain, and largely paper-based. Where systems underperform, businesses either operate without protection or disengage from formal registration entirely. Trademark activity tracks economic formalization. As African markets deepen integration under the African Continental Free Trade Area, filing volumes will increase. The question is whether existing systems can absorb that growth. It is also important to address a recurring misconception regarding costs. Africa is frequently characterized as expensive for trademark registration, but the data does not support that position when official fees are examined. Nigeria's official filing fee is approximately $22 online. Morocco's is about $176. South Africa remains similarly competitive, while Kenya charges approximately $200 per class for foreign applicants. Tunisia sits at roughly $178 per class, and Ghana ranges between $240 and $440 per class. By comparison, the United States Trademark and Patent and Trademark Office charges $350 per class. The United Kingdom Intellectual Property Office, approximately £205, and the EU Intellectual Property Office, €850 for a single class. This issue is therefore not the cost of registration. The issue is the cost and complexity of enforcement. That imbalance, where registration is relatively inexpensive, but enforcement is uncertain and often expensive, represents the structural gap that reform efforts must address. Nigeria's trademark system itself follows a clear legal framework governed by the Trademarks Act, Laws of the Federation of Nigeria, 2004. It comprises search, examination, acceptance, publication, and opposition. Once a trademark is published, an opposition may be filed within 2 months, and the applicant must respond within 1 month, failing which the application is deemed abandoned. Evidence is then exchanged, and the matter proceeds to determination before the registrar. In West Food Company Limited and Promideso IP Holdings Limited 2022, the tribunal refused the mark Carmela based on its similarity to Cremella, applying the likelihood of confusion test under the Trademarks Act. The legal reasoning was sound and methodical. However, the system within which such determinations are made has not kept pace with demand. Evidence exchange remains largely paper-based. Notifications are still often by post, and the time between publication and determination introduces uncertainty and significant commercial consequences. This environment also sometimes enables bad faith practices. in Chief Sir Elazor Izegbo and Prince Nyom Inyong Effiong and others, the Court of Appeal held that compelling an individual to participate in an association as a condition for economic activity violated constitutional guarantees. Trademark squatters operate on a comparable logic, using procedural control to extract concessions from legitimate rights holders. The form differs, but the effect is the same: coercion enabled by systemic gaps. Recognizing these challenges, Nigeria has undertaken a structured policy approach. In November 2025, the Federal Executive Council approved the National Intellectual Property Policy and Strategy, with implementation structures inaugurated in January 2026. The Interministerial Steering Committee, which I co-chair with the Honorable Attorney General and Minister of Justice, provides political oversight, while an interagency coordination group drives technical implementation. What does the NIPS say specifically on trademark prosecution, dispute resolution, and enforcement? On prosecution, the priority is automation. The Trademarks Registry has commenced deployment of the WIPO iPass cloud system to digitize filing, publication, and opposition processes. The immediate focus is on opposition phase, where delays are most acute and most damaging to rights holders. The objective is to transform opposition from a procedural bottleneck into a credible and efficient adjudication process. On dispute resolution, the policy introduces structured alternative dispute resolution mechanisms for procedural and compliance matters, while maintaining judicial authority over substantive infringement. On enforcement, it mandates technology-enabled monitoring systems, structured interagency coordination, strengthened border enforcement frameworks, and sustained capacity building across the judiciary and enforcement agencies. In closing, as Africa advances under the African Continental Free Trade Area, trademark systems must evolve in parallel. Where prosecution is slow and enforcement uncertain, market integration will outpace legal protection, creating opportunities for abuse that undermine both African businesses and global brands. Nigeria's position is clear: a system where registration is inexpensive but enforcement is inaccessible is not sustainable. So that is my priority and the priority of the Federal Ministry of Industry, Trade and Investment. A process where procedural delays erode the commercial value of intellectual property rights cannot be maintained. Trademark systems are judged by their outcomes, and the focus of current reforms is to deliver outcomes that are credible, predictable, and enforceable. So I wish you fruitful deliberations, and thank you for the kind invitation and for listening. I hope those are applause I can see because I can't actually hear you. Thank you.
There was a very big round of applause. Teams has this really noise suppression technology, which is wonderful if your dog is barking, but terrible if you're listening to an audience or something. Thank you so much, Dr. Oduwole. And now I don't know if you are happy to take any questions, or if you we do have a couple of minutes if you are happy. Otherwise, it will be a well-earned already, because that was quite a remarkable, wonderful presentation. Coffee break.
Yeah, before we go.
Yeah, I think, okay.
I just also wanted to say, because when Johanna was reading her bio, one thing was missing there, that it was during her time at the PEBEC that she pushed for some reforms in the law in Nigeria under the Business Facilitation Act that allowed registration of service marks, ships, and some form of colors. So I think we should give her another round of applause.
Thank you. Thank you very much, Prof.
That's actually interesting, because I'm hoping we're going to have a chance to talk a little bit about non-traditional marks this afternoon as well. So thank you so much again. We wish you well for the rest of the day. And we will now have a lovely coffee break. Thank you so much.
Bye, everyone. You're welcome. Bye-bye.
Okay, so it is now time for a quick coffee break. So welcome back from coffee. Now to our panel discussion and Q&A. So this will be an opportunity to discuss some of the major issues, jurisdictional issues, regional issues with respect to prosecution and enforcement in each area of expertise of the distinguished panel. And then we will have, I hope, an opportunity for a really exciting Q&A, because we've got a lot of wonderful people here, and I think that would be a very useful and important part of this event. And then we will be moving to lunch, which will be out there, unless a horde of students between exams has come in and just swept the table clean, which does happen, but we're hoping it doesn't happen today. So I'd like to introduce you to the speakers. So first, we have Pascal Haddad. There we are. Pascal joined Saba IP in 1999. He now serves as a shareholder and country manager at the Morocco office. Pascal provides IP, legal and strategic advice to clients based on best financial, taxation and legal practices in Morocco and the MENA region. Before joining the Morocco office, he also headed the IP. He also headed the IT department at the head office. Pascal has a very exciting practice. He has focused on all systems and workflows, including the handling of patent annuity payments across the MENA. He holds a diploma in electrical and electronics engineering from the Lebanese University and a postgraduate diploma in IP laws from the University of London. And that is certainly a very useful mix to have in today's legal environment. So Pascal is an IP consultant registered at the Moroccan Office of Industrial and Commercial Property, and he's a member of the Engineers Syndicate of Beirut and a member of the Intellectual Property constituency of ICANN. Then we have Femi Fajolu, and Femi is the managing partner at a wonderful firm. I don't know if you've heard of it. Sodipo and Co, where he coordinates and advises a wide array of clients on various areas of the law, such as corporate and commercial law, intellectual property, media and entertainment law, insolvency and capital markets, labor law, taxation, wills and estate law. I'm really thinking, Femi, we're going to have to ask you to come in and teach on the fashion law program, because you're ticking a lot of boxes here. He's acted as a team leader in various intellectual property transactions and is equally a voracious litigator who combines intellectual depth with a prowess in advocacy. He's worked with the United States Department of Commerce to organize and take part in programs on IP rights, government ethics, and project finance. He's involved in the formation and setting up of the newly proposed Intellectual Property Commission. He has involved with advising the federal government on the private sector initiative of the intellectual property regime and compliance with TRIPS in the WTO. But prior to joining Bankole and colleagues at Sodipo and Co, he worked with CSS Bookshop, Sola Akinyedi, Adinyi Koka Architects, where he was the company secretary and head of administration. He's a member of the Nigerian Bar Association, Intellectual Property Association of Nigeria, and the Christian Lawyers Fellowship of Nigeria. He's active in several domestic and international organizations that seek to promote good governance and improve business relationships amongst developed countries, Nigeria, and other African countries. So this is very invaluable expertise for today's discussion. John Hull is next. John is managing partner at the Nico Hull & Co law firm. He heads up the firm's corporate and commercial department. He is admitted to the Cameroon Bar and the New York State Bar. He provides legal and advisory services on banking and finance, capital markets, commercial contracts, insurance, investments, mergers, acquisitions, divestitures, private equity, project finance, public-private partnerships, and restructuring. So many things I had to take a breath in the middle. His expertise also includes administrative and regulatory compliance, business law, corporate and commercial practice, corporate finance, global mobility and corporate immigration, intellectual property and innovation, labor and employment, investment, litigation and alternative dispute resolution, and tax. And I did that without a breath. So amazing array of expertise here on coming from the Cameroon perspective. So John advises clients on a wide range of corporate, commercial matters and transactions in Africa, especially countries of the Organization of the Harmonization of Business Law. He covers a lot of different industries, including agribusiness, energy, transport, telecommunications, and has what I think is incredibly important and interesting expertise and experience in natural resources. He provides advisory and legal services to matters pertaining to oil and gas concessions, exploration, and forestry exploitation. And so I'm delighted that you're able to join us, John. Mwangi, Meneses Kabui Mwangi, is a seasoned legal practitioner. He's had a distinguished career of more than 15 years post-admission experience. He holds a Bachelor of Laws and a postgraduate diploma in legal practice. He's also a registered patent and trademark attorney. He's admitted to practice before the Kenya Industrial Property Institute. Over his career, he has represented banks, multinational corporations, public bodies, state corporations, county governments, and private clients before tribunals, the High Court, the Court of Appeal, and the Supreme Court of Kenya. His portfolio spans construction disputes, constitutional litigation, election petitions, IP protection, tax controversies, and governance matters. He's also acted as an arbitrator in domestic and international disputes. Meneses has served as a board member of the Kenya Industrial Property Institute from 2019 to 2022, and he's also the founding convener of IP Check-In, a monthly forum on intellectual property law. He's a fellow of the Chartered Institute of Arbitrators with expertise in JCT and FIDIC contracts management and dispute resolution, and he also serves on the panel of neutral arbiters of the World Intellectual Property Organization. So welcome, Mwangi. David Mills, moving right to WIPO, in fact. So David is currently the Senior Director of the Madrid Registry in the Brands and Designs sector of WIPO. So in this capacity, David is responsible for all legal, operational, IT, and promotional aspects of the Madrid system for the international registration of marks. He joined WIPO in 1997. He first worked on intellectual property issues raised by the internet. I remember those days when that was all we had to worry about, including domain name dispute resolution. He later joined the Patent Cooperation Treaty, where he was director of the operations division. More recently, David was in charge of the Department for Trademarks, Industrial Designs, and Geographical Indications, where his responsibilities included the WIPO Standing Committee on the Law of Trademarks, Industrial Designs, and Geographical Indications, as well as the Lisbon system. David is a Belgian national. He has law degrees from the Faculté Universitaire Notre-Dame de la Paix in Namur and the Catholic Universiteit Leuven and Columbia Law School in New York. Prior to joining WIPO in '97, he was an attorney at Baker & McKenzie in Brussels, a legal assistant at the Iran-US Claims Tribunal in The Hague, and a head of section at the United States Compensation Commission in Geneva. So welcome, David. Dr. Martins Iluyomedi, I'm sorry, that was I practiced and I bottled it. Is a distinguished leader in pharmaceutical regulation and public health enforcement in Nigeria. He currently serves as director of the Investigation and Enforcement Directorate of the National Agency for Food and Drug Administration and Control, NAFDAC, and chairs the Federal Task Force on Fake and Substandard Products. Okay. With over 2 decades of dedicated service at NAFDAC, Dr. Iluyomedi, I'm so sorry. Why can I not? Victoria, where are you? You gave me a tutorial. Iluyomedi. Yes! I'm sorry, I'm Australian. We can't pronounce anything. Before joining NAFDAC, but over 2 years of dedicated service at NAFDAC, you have held pivotal roles, including Director for the Southeast Zone, October 23 to June 25, Deputy Director of Investigation and Enforcement, 2015 to September 2023, and the Nasarawa State Coordinator in 2011. His tenure has been marked by strategic enforcement operations that have significantly curbed the circulation of counterfeit and substandard products across Nigeria. Among his notable achievements, Dr. Ilu Yomedi, I'm sorry, it's become a, has led a high impact operation in December 23 and 24 that dismantled illicit beverage production. Now, this is really quite significant because, of course, there's a lot of different factors here, but it is another example of the interaction between trademarks and public health and product safety. So these intersecting issues will something that I hope we will get into in the enforcement discussion in particular. He directed a simultaneous crackdown on drug markets in Onitsha and Aba, resulting in the seizure and destruction of over 100 trailer loads of banned and dangerous substances, including tramadol. Earlier, influences everywhere are distraught. Earlier in his career, while serving with the Ports Inspection Directorate, he intercepted a falsely declared consignment containing obsolete anti-malaria drugs. The successful prosecution of the perpetrators in Nigeria and China earned him international recognition and an accelerated promotion. His academic credentials include a bachelor's degree in pharmacy from the University of Ibadan, a master's in pharmaceutical science, clinical pharmacy from the University of Lagos, and a master's in peace, security, and strategic studies from the University of Ilorin. He is a certified expert in international public policy in Africa, a fellow of the National Institute for Security Studies, and holds a PhD in strategic management. He's a recipient of the DG Special Award for Excellence in Regulatory Enforcement and exemplifies, if I may say so myself, and integrity, strategic leadership, and an unwavering commitment to public health. And beyond his professional accomplishments, he's also managed a family and in amongst this impactful career of a father of 3, I believe. So finally, we turn to, but not least, of course, but finally we refer to Desire Lumu, who is head of the Intellectual Property Rights Division of the African Continental Free Trade Area Secretariat. So I imagine that Mr. Lumu is going to get quite a lot of attention in the discussion today. He is a lawyer and patent and trademark attorney, and he's especially regarded for his highly specialized knowledge of the multilateral trading system, not only in intellectual property, but also environmental law. And this is really significant expertise for today's discussion, because of course there are significant challenges around multilateralism and even the future of the multilateral system, and at the sort of the current climate, the current international climate, these discussions are really, really important. And we're focusing on them from the trade perspective, obviously in trademarks, but that is a perspective that really governs so much of what we are doing and so much of the way in which countries interact with each other in this landscape. So I'm really delighted that Mr. Lumu can be here, albeit online, I believe. May I just check, Maham, that Desire, and with you, Desire, have you been able to join?
Yes, they're on here.
Oh, fantastic. Wonderful. Okay, that's great. So I might stop sharing and put Desire up on the screen. Although if you're happy to turn your camera on. Oh, there we go. Where is it gone? You've done it for me. Thank you. Okay, so how we're going to do this, Bankole, is we're going to talk about prosecution aspects first, and then we'll turn to enforcement. So do you want me to start? Okay. So Pascal, we thought we would start with you. But first, to the panel, obviously the African continent is very diverse. And the African Intellectual Property Organization and the African Regional Intellectual Property Organization represent more than 20 countries and approaches and perspectives that are different from one country to another. And this is very significant, both in terms of challenges, but also opportunities. So we have the benefit of expertise across the region assembled in the panel today. And what we would like to do is come to each speaker for insight in your particular region. So Pascal, we'll start with you. And what we'd like to get is your perspective from North African countries. What are the distinct challenges for prosecution, registration, and brand development in such a diverse area? So even before we get to questions around enforcement and drawing upon our keynote, thinking about the value and the importance of the mark in the first place, what are some of the key challenges and opportunities?
Thank you for the invitation. Thank you, Professor. First of all, I did not prepare a presentation, so it's like I would like to have an interactive discussion, which is much better probably. In North Africa or in the Maghreb countries, which we cover, like Morocco, Tunisia, Algeria, Libya, and Egypt. Of course, we have a well-established system for trade design, because I believe that some of the designs would cover are similar to trademarks, like for trade dresses or something similar to this. So we have a system to IP protection, of course, since the 1900s. In Morocco, it's a very smooth system with absolute grounds only. We don't have relative grounds, which make it like we have many opposition, we have many trademark squatters, we have many actions later on for assigned back actions. This is similar to Tunisia. Since the prices are somehow they are cheap in Morocco, we have a lot of trademark owners who are locals. Probably 80% of the trademarks are filed by local owners. In Egypt as well, we have such a system. In Algeria, we have relative grounds of examination, which make it difficult for squatters to have trademarks on behalf of the rightful owners. And for Libya, we have a very complicated system for now, based on the, since the revolution and the change in the system and the government, things were not moving straightforward. Nowadays, we have a trademark renewal which costs 20K USD, which means 2,000 per year. The people in charge of the IP there, they are probably not very well experienced, so they are changing the law based on I don't know what exactly, but things are moving like not into the right direction, and we have like a lot of changes, very surprising in their system. Of course, since 25 or end of 24, we have no publications of trademarks. So, and still all the trademarks are under publication. So if we need to do a search, we cannot do it online. We don't have a database. It's a bit conflicting or challenging to us. While in other jurisdictions like Morocco, we have every 2 weeks a trademark publication of gazette, every 1 month a design gazette. In Tunisia, we have every 3 months a publication which will publish as well the WIPO trademarks. Algeria, usually we have every 2 or 3 months publication. Since late 25, we do not have any publication, but we believe it will soon be published. One of the challenges is mainly the trademark registration in Arabic, since all these jurisdictions have the Arabic language, and we have sometimes in the use in Arabic is very important. So based on the use, we always advise the clients or the trademark owners to file the trademark in Arabic, because in case the trademark is not filed in Arabic, you don't have the proper protection for its variation. And as you know, you probably know about the Chinese way of variation of trademarks, where you have a change in one point or adding a sign will change the whole meaning of a word. So this is the same in our region. So it's always very beneficial to the client to have his trademark used, protected as used with the Arabic transliteration. I think I covered all the main points of prosecution, but I'm ready to have your questions or to pass to another colleague.
Would you like to do
What
that,
do you-
Bankole? I mean, I think it's quite interesting what you're raising about the institutional challenges, but also specifically different levels of experience.
Mhm.
I mean, is that an opportunity if we're looking at a more unified market? Is there an opportunity to address differences in experience as well as substantive differences in law and procedural differences when it comes to administration?
Yeah. Again, based on our practice, I can say that even if the law is, let's say, well established, the practice is sometimes changing between a country and another. People, we are all human, and you have always a new effort or new elements coming in and trying to establish their own personality between brackets in the practice. So you feel that sometimes, since we don't have like a database of let's say decisions or jurisprudence, so even in whenever you have like rejection based on absolute grounds, the same trademark filed after a while, it will be accepted. So it's always a challenge. Like in Morocco, you cannot use any emblem or anything related to His Majesty the King. So you cannot, let's say, a trademark like Burger King, if it doesn't have any notoriety, like Burger King, for example, it will not be accepted. So, and I think this is as well applicable in other jurisdictions where you have like a royal system. So this is in Morocco, for example. In other jurisdictions, sometimes any like a trademark filing will take years for acceptance, like in Libya, for example. In Algeria, sometimes trademark are smoothly accepted and others are left without any publication. And this is why we need always to be interactive with the trademark office to try as much as possible to reach like a favorable or outcome of any trademark filing. I don't know if
Yeah, I mean, I think what's interesting there is the lack of resources in one respect also perpetuates that differences in experience.
True.
And so you have a growing kind of gap between the expertise of one office compared to another. And so in some respects, would you think that addressing procedural efficiency across the region might assist that? Like we might see more.
Yeah, but by the way, I probably missed that most of these countries, except Libya, are part of the Madrid system or protocol. The main issue, like again, I'm having an example as Morocco. It's very smooth. Like in case you have a trademark filing without any like. Some elements which needs to be addressed or for examination, which are straightforward, you will have a trademark registered in less than 3 months with as well a registered certificate. The main problem in Tunisia, it's as well like few months more. Algeria, it's more. Egypt, it's like Tunisia. And Libya, it's, as said, it's chaotic. The main issue in trademark registration in this region is subject to human, like we don't have like to follow a database, even in oppositions, even in like examinations. So it's up to and sometimes we had many cases where trademarks were accepted, were rejected, and then a similar, identical, not similar, trademark was accepted. So we had to intervene and send objection. But even the trademark office really listened to us. So they do not close the doors. I need just to add something that for WIPO trademarks, since WIPO trademarks are designating our region, we have only in Tunisia we have the publications in the local bulletin, while in other jurisdictions like Algeria, Morocco, and Egypt, they only mention the name, the trademark numbers. So here you might, if you have a surveillance in the country, you might miss such publication to oppose. And opposition, it's between like 2 months or 1 month to oppose. Lastly, like in Morocco, they have the same system and Tunisia as in France. So you don't need to have a POA to act on behalf of your clients. Since you are a CP, what we call the CPE, which is Conseiller en Propriété Intellectuelle, you don't need any POA, you just act on behalf of your client.
I think that's very interesting. I mean, so you talked about sort of just attending the same kinds of standards in examination almost by rote, and so ending up with the same sorts of marks all the time. If we could turn to you, Femi, I mean, it's I know how David feels about this, so I expect to see an eruption. But and especially, I mean, an interesting area of trademark law, albeit I'll concede to David, somewhat niche, is non-traditional marks. And the reason I ask you this is because, of course, the different jurisdictions are dealing with non-traditional marks in different ways. And Femi, of course, Nigeria certainly has some interesting jurisprudence in respect of shape marks. So I wondered, might this change at all, or would any of this change with the adoption of the annexes, do you think?
Thank you. Good morning, everyone. We, even prior to the amendment that we had in 2023, as relates to non-traditional trademarks and issues of shapes and the like, we, under the old laws, our courts have enforced non-traditional marks as it regards shapes. And a very good case in that is that the case of Duracell batteries, shapes and colors. Nigerian court, Federal High Court, awarded heavy damages and injunctions against the defendants in that case, where they copied the shape of Duracell battery and the colors, multiple colors of that battery. Nigerian court enforced that trademark, under the old laws. Now, under the new laws, we have wider varieties where you can come to court. I think the most important thing is getting a good lawyer who will present the case very well. We have enough laws to protect you if you have protection, if you have registered trademarks in shapes and colors. Another example where we were involved in the cases was the shape of the big biro, the big pen, ballpoint. We did that case for Associate Big. And we were able to settle. The case was in court for several years. But because we presented that case very well, the opponents, we obtained an unpopular order. We stopped the production of the opponent's big biro. So, because the Associate Big registered the shape of that barrel. And the court was ready, to protect our marks. We got an injunction. We raided the opponent's company, and we practically closed the company. The opponent's company is dead right now. So under our laws in Nigeria, we have protection for non-traditional trademarks, and the courts are enforcing them.
I think that's actually quite interesting, because when you're talking about shapes and colors of bottles and so forth, I mean, there's an interesting interaction with some of the comments we were discussing earlier around trademarks and product safety, because of course lookalikes are a big issue everywhere. And largely there's not much you can do about it. It's generally not going to be passing off. There might be a design protection in a bottle, but then so you've got, you know, it sounds like, okay, people are getting confused at the pharmacy, but then you have a potential issue where it points to how color and shape does communicate something.
That's right.
And you are in a position where working quickly, you do get confused. So it's working as a mark of origin in those contexts.
Yeah.
So it kind of points to how we read and experience marks, but it also, I think, very importantly, shows us again that important interaction between trademarks and product safety, like the public interest in trademarks.
That's right.
And I think perhaps if I could turn very quickly to you on this, Martins Iluyamadi. Did I get it right? Yeah. Oh, sorry. Yeah, a question. Oh, the mic. Sorry.
You talked about prior to the amendment that your firm, the courts in Nigeria protected trademarks, for example. The Duracell case. You mind if you don't mind, which case law were you relying on? Were you relying on UK case law, or case law elsewhere, or case law in Nigeria? Okay.
Oh, we need the mic. Sorry. Sorry. Does this work?
The opponents in that case did not actually infringe on the trademark. It was basically on the colors and the shapes. In that case, you know, the Duracell battery, peculiar color, peculiar shape. They are different names, but the court still held that, yes, because these shapes and colors, you know, were registered, they were protected. And they got injunctions, permanent injunctions, and damages in that case. If you give me a card, I'll send you.
Sorry, we're trying to work out it. Oh, you know, yeah, that's okay.
Are single colors protected, and does the trademark office take into account that a certain color might be very popular, like red or black, before it registers a trademark or protects it in litigation?
Again, if your mark is not registered, again, you know, you're fighting issues of passing off, what you call trade dress in its place. From the cases I've reviewed in Nigeria, it's very difficult to win the passing off case. I'm telling you, because you really have to be very good at proving your case. Your evidence must be very, very strong, you know. And a lot of times from the cases I've reviewed, there are not many cases like that where your trademark is not registered. That's why we encourage SMEs as they're starting. Register your trademarks. Register every aspect of your trademarks, even defensive trademarks. Register so that you'll be protected.
So what I was thinking, if maybe we could turn to you, Martins, because of course it kind of, if we can just look at this shape color question for a second, because I think it's an interesting part of trademark law is, of course, trademarks as an informal kind of regulatory tool. Because there's an increasing attention to trademarks and their role in communicating health information and other information, you know, informally or otherwise, and a lot in particularly with respect to beauty industries and beauty ideals and so on. So Martins, given your particular expertise, and Femi, if you can come in on this as well, because you've got a special expertise in this too, I wonder if you could comment on this in the Nigerian context, which of course where we, you know, what we're paying attention to now. Do we need to pay more attention to the relationship between trademarks and public safety?
Definitely, yes. Especially in our context where for NAFDAC, before we get your products registered, you have to present your trademark certificate. It's one of the major requirements. And it's because we've had a lot of litigations of passing off all of that after a product is registered. This has to do a lot with, there's an intercept of this with health, because one of the places we have the major passing off issues are in cosmetics. Major, they have so much, and because that trend keeps changing, you see a cosmetic product that is moving right now. Tomorrow, somebody want to copy that brand that is moving, and then we see a lot of cases like that. I want to give a particular instance here. One, there is a low level of awareness amongst just like my senior colleague just mentioned, there is a low level of awareness amongst SME holders in Nigeria about patenting their products. They just feel, why waste my money? Why spend money? And now when they now see their products being, when people are infringing on it, it's a difficult case. Because, okay, I'll give a very good example here. Just last week, before coming down here, I presided over a case where two friends, they know each other very well. And so they opened their business secrets to each other. So one of them saw the product, and it's a cream. I'm giving live examples now. One of them saw the product. They discussed that these products will move and they will do very well. Number one is an international brand. So I'm going to create this awareness there. So they discovered that the brand owners have left the country. That particular product is not being pushed by the owners anymore. So they said, okay, well, this is a good thing. Let's quickly. So they copied that. In fact, they took the name of the company, copied everything, and the two of them discussed that this product, we're going to move it, and they started. So one of them went to trademark to go and patent that product, and he got it. So there's a lot of intercessions here. The second person did not go to trademark. He went straight to NAFDAC to go and register. So one did trademarking and kept the trademark. The other one did not wait for trademark, came to NAFDAC to register. And you wonder, so what trademark certificate did he use? Fake trademark certificate. And I'm giving you real life situation, and it was registered. So the other friends saw it and saw this is a betrayal. I am the owner of this. I registered this trademark, even though I have not approached NAFDAC to register the product. But since I'm the owner of the trademark, I'm the owner of the product. So they brought the case for adjudication because they wanted, his grounds is that we should void that registration, that we should remove, because our law says if the premise on which you register a product is false, we're going to deregister that product. So he came on that premise, and it was a lot of work for us to be able to discover who owns the trademark first. So it was last week I got a response because we wrote to the trademark office, who now responded and said, yes, this particular person who has not filed any application with NAFDAC had registered a trademark before this other person. And by the time we checked the other person's trademark, they said they cannot find it in their record. So the next thing is to deregister that product and remove it, even though the other guy too cannot still use because he has not he has not applied for us to do. But why I'm bringing all this interception out is because our trademark office has a lot to do, because particularly in our own area where we have to do with food and drugs and something that has direct relationship with health, they have to do much more. But I'm happy now they are moving to digitalization. They are trying to digitalize that system so that it can be easy for checks. Because sometimes when you write to check the status of products, it might take you ages to get that, and people use that that opening to do a lot of things and all of that. But I think they are trying to build that up now. So there's a lot of correlation where people need to be aware, and there's intersection between health and trademark. Thank you.
Yeah.
Thank you.
Good morning, everybody. Prof, thank you for putting this together. It's just absolutely fabulous what you've done here. And my esteemed regards to all the members of the panel. Quick one. What I would think, one thing I'd like to contribute readily, and it flows from your question, is that if I were a brand owner, or if a brand owner approached me, my personal view, and it would be that your first port of call is to get your trademark portfolio in order. Get your trademark portfolio in order. You need to interact with the regulator, NAFDAC. And please forgive me, Professor, this needs to be said. The regulators there needs to be a proper synergy, that he has to write a letter and wait 3 months to get a response. Doesn't work. I'm hoping that the minister is able to bring our incredible talents to bear on the trademark registry, because this is a registry. Sorry, if I'm washing our linen in public. This is a registry that you go to the digital portal, you can register something or apply for something, come back 3 months later, you don't see the registration. So for all you know, it's possible in the story you told us that you could circle back another 6 months and say, well, we found it somewhere. So once there's a synergy with the regulators, yourselves, SON, the trademark registry, then this thing should work seamlessly. Brand owner comes and he gets it all done neatly. So that would be my counsel generally in dealing with these things. Then one final thing, please forgive me, Femi. I don't fully agree with you that what you call a passing off is a weak tool. It's actually very powerful tool. And the very first case I did with Professor Sodipo was exactly that kind of case, where the look and feel of the products were the same, but the names were different. And though it got settled, but it allowed us get interim relief at the beginning. So I think, there's no, I can't detract from what he said, which is register. But assuming, you don't have a registration, you don't have boots on the ground, or the brand owner hasn't seen it fit to, he can still, rely on passing off. I think it's a powerful tool personally. And if I have the evidence, I'll make it work. Like I assure you. Thank you.
I think it's an interesting point, especially because it brings together again our attention to procedural efficiency as part of the resources of the trademark applicants and the trademark users and the public. And part of that efficiency is, of course, we've heard questions around the availability of databases, but part of that efficiency is also time, so online resources. And I know Mwangi, and you have, sorry. Yeah.
One area that a lot of people are not looking at is the conflict with the registration of company names. Sometimes you don't have a trademark, but you have registered a company. And our law says if you have that name, even though you don't have a registered trademark, but you are using that name as your company name, whoever registered a trademark using that name will be violating your company registration name. They will give that person priority over the trademark. When you have a trademark, the person can ask that your trademark should be cancelled. Again, talking about harmonization. The company registry and the trademark registry are not harmonized. And we've done a case where there's a trademark registration by the opponents, but our clients had a company registration that spanned more than 30 years. 30 years. So we were able to restrain the person that has a trademark using the company name, major brand in Nigeria. We stopped them. And the opponent was actually a foreign major US company. But we had a company registration small over 30 years. And the court looked at it and they said, yes, in line with the section of the Companies Act, Matters Act, we have priority. And based on that, the court granted an interim injunction. The court granted an interlocutory injunction. When we got in that interlocutory injunction, the opponent settled. So I just thought when we are doing trademarks, conduct a search at the company registry to ensure that, is there priority, this name that I want to use as trademark, is somebody already using it as a company name? At the end of the day, we're talking about names.
Yeah, I mean, it's interesting because again, that also highlights the public. And I mean, we're talking about people and their interest in their company name or their interest in their trademark. But the counterpoint to that is also that the other group that's confused is consumers. So you had that uncertain environment for consumers as well. I think we keep on this topic of that efficiency and that efficiency as a resource. John, if I can turn to you, we'll be coming to enforcement obviously in a moment, but to what extent do you think an uncertain enforcement environment in Cameroon is actually facilitated, at least in part, by an uncertain environment for registration and prosecution? So they're so interconnected. And when we talk about an uncertain enforcement environment, where actually it's being fed by this uncertain prosecution environment.
Thank you. To begin, I would like to bring a different perspective to what my senior here spoke about. Being able to reverse an application, a trademark application, based on the fact that a company is being registered. The OAPI jurisdiction is a centralized system governed by the Bangui Accord, which was adopted in 1977, revised in 1999, and most recently in 2015. It's a centralized system that covers 17 African countries, and you just have to file your application in Yaoundé, and the proceedings accrue. Now, with OAPI, the rule is this: first to file, first to register. So it doesn't matter that you may have a mark that is notorious in the territory. If I filed an application for that trademark, the right is mine. Now, as the user as somebody who is already in the field, you can engage proceedings for claim of ownership, showing that you've exploited this particular brand or mark notoriously within the region. As to the fact that, you may have registered a company, that is inconsequential. There are different routes you can take. Company law and is governed by the OHADA Uniform Act. It's a harmonized system for business law in most of Francophone Africa. So if I have a company with a particular name and you register a brand with that same name, I cannot seek recourse with the institution, with OAPI. I have to go to the local courts to get a court order and to proceed with the cancellation of that mark. So I thought it's important that that's the OAPI jurisdiction. It's a unique system, but I think it's very advantageous because of the broad scope of protection it provides. You just have to file one application and you are covered in all 17 African countries.
Yeah.
The challenge with that comes now with prosecution, maybe infringement proceedings. The Bangui Accord doesn't
provide for, I would say, very sophisticated means of enforcement. Yes, you can prosecute, but when you get now down to infringements and searches and seizures, you need to rely on the local courts.
Yes.
And that's very challenging.
Yeah.
It's very challenging. Each country has a different.
I mean,
no, I didn't even talk to her. I think she copied what we did before in the.
oh, no, it's not design. Who's on? I can't. Oh, there's somebody. And sorry, Tunji, did you have a question? No, just okay. You're not. Do I mute? Do I? Okay. Okay, that's. What was I going to say?
Yeah.
I've forgotten. Oh, I was going to say, yeah. So the question around business names similar here.
Yeah.
So it's not what you would be looking at is what you were saying is you'd have to say, okay, well, we've been trading under this name for years, even though we don't have a mark. But what about goodwill? So maybe passing off. But yeah, it's not a certain sort of and a lot of small sole traders like designers and so forth think, oh, I'll just register my business name and then I'm fine. I'm done. That's all I have to worry about. And then they come really unstuck. And that happens quite a lot in those that sector at least, where you're talking about individuals who are doing their art or making their furniture or what have you, and they think that a business name is a trade name. But what it does point to, of course, is that interaction between how these things work.
Absolutely.
And how you develop goodwill and how you recognize something as being an identity. But I think it's a really important point, and it also points, of course, then to the challenges across a single market.
Yeah.
And also keeping with resources, Mwangi, could you take us through the prosecution environment in Kenya, but particularly what's interesting is challenges around online facilities, because I know you've raised this in discussion previously. There's also very interesting developments in the registration of geographical indications. So and we've discussed that as well, and also, but as a dimension to trademark strategy, which I thought was fascinating when I was talking to you about that in our pre-workshop meeting. So is there an interesting link there, and also to branding more widely, that we should be thinking about when it comes to geographical indication? It'd be very interesting to consider that in more detail.
Thank you very much, Johanna, and my fellow panelists. I had made a short presentation.
Yep, I can share it.
This kind of discussion sometimes can be an unruly horse. Once you are astride, you don't know where to take you. So it could be the point the in. But as we said that, just a comment on what my two learned friends have said about registration of company names and trademarks. In Kenya, we have a slightly different approach, where we don't have a straight jacket rules on how to treat prior registration of a trademark or a company name. But the defense of own name registration of a trademark is not available to a body corporation in Kenya. It's only available to natural persons. And the Kenyan judicial system, we have leaned more towards the good faith. You must be able to establish that there was bad faith in registration of your company name as a trademark. And this has been determined even before the advent of the Sky Creek case in Lado versus Lando, and the courts have been, so long as you're able to produce evidence to demonstrate bad faith, you are able to win back your trademark. Doesn't matter the number of years or the amount of goodwill. The starting point is, was there good faith, was there bad faith at the initial point? And here you just initially have to demonstrate there was prior interaction with the infringed or the offended mark before you registered it. Back to my presentation, I would like to highlight a few developments that have happened in the Kenya and the East African region. I think that will also be able to obviate many of the questions that the audience may have. Starting recently, about 3 weeks ago, Sone was declared as not a well-known mark in Kenya. And this was a decision of the Court of Appeal. And so that appeal, where the court dealt mostly with legal issues only, the court underscored that WIPO joint recommendations and the inter-guidelines on determination of well-known marks are applicable in Kenya, and that is the test applicable in Kenya. These are steps towards harmonizing trademark law to accommodate even foreign marks. Section 15A, you must be able to prove evidence territorially to be able to establish well-knownness in Kenya. So it doesn't matter how much well-known you are outside the country, you must produce territorial evidence. That was a very important determination. The second slide, the other important principle of law that was determined in this case is application of Section 14 of the Kenya Trademark Act. And basically is the application of the test of likelihood of the confusion, the notional test and actual confusion. And the court was very clear, so long as the marks have been in the market, albeit for 4 months, that is important period to consider. And at that point, the competent authority of the court must consider actual confusion. And this was, in a sense, domestication of the very famous case of British Sugar versus James Robertson, a decision by Justice Jacobs. The next slide. The next one. In Tanzania, that case of Rakairo Industries Group Limited and others versus Canafric Industries declared that Tanzania had not properly acceded to the Fajolu protocol that establishes the ARIPO registry. Next slide. What that means is many of the designs, trademarks, and patents registered under the ARIPO protocol do not confer rights in Tanzania. This has presented difficulties, of course, in enforcement, including fighting counterfeits, even the border crossing points. And this decision, which was again a decision of the last Court of Appeal in Tanzania, brought into sharp focus the two principles of monoism and dualism in international law system. And we would have been interested to see what would have happened if one of the parties was a foreigner. Because once a country contracts by the treaty, it binds itself to the foreign nation. It cannot then again come and plead its own municipal difficulties to say that, no, this treaty cannot confer you rights. But unfortunately, these parties were both nationals of Tanzania. We can go forward. So what is Tanzania doing? They have tried now to enact a registration to formally domesticate the Fajolu Charter, and that that registration, which is the Statute Law Miscellaneous Amendment Act 2026, proposes to retrospectively validate all the rights that have been registered under that system. And you can see section 89, subsection 2 of that Statute Law Miscellaneous Amendment Act that creates a legal fiction, a deeming fiction. This bill is now in the second reading and it's about to go to the third reading, and perhaps it's passed into law, then we do not have that problem with ARIPO. But I still feel that the foreign marks, the foreign IP owners, they should be able to claim rights in Tanzania, but now that's a debate. Let us wait for the enactment of the law. The next one. Recent development in geographical indications. Towards the end of last year, the Kenyan Court of Appeal made a determination. There was a conflict between India and Pakistan, claiming the geographical indication basmati rice. Which of the two nations should have the geographical indication basmati rice? This is a region that cuts across both countries, and both of them were fighting in Kenya. And the next slide shows in this decision, Kenya Court of Appeal, Civil Appeal number 610 of 2019, which was also that appeal, purely determining points of law. The Court of Appeal basically underscored the fact that if a geographical indication is not registered anywhere in the world and in Kenya, it cannot obtain protection in Kenya, and it cannot be a basis for challenging any other trademark right, whether pending or already registered trademark. We are going to see what Kenya is trying to do in the next slide. So Kenya has now proposed to migrate from the trademark system of registration of geographical indications, which is analogous to the system used by United States of America. And we want to come nearer Europe, the system of sui generis registration. So you have a geographical indications bill 2006. It went through public participation the last 2 weeks. And now it's awaiting presentation to Parliament. Of keen interest in this bill, it proposes to protect unregistered geographical indications. During public participation, it has elicited a huge debate as to how will you recognize an unregistered geographical indications when a right in a geographical indication is only conferred through registration. How are you again going to determine invalidity or compliance with either the technical file or the regulations that govern that particular geographical indications? And if it's not registered, because the bill requires that the county governments will form or have a repository, will it then form a repository of any of the registers of geographical indications? But also the bill, it's remiss. It has not made provision for registration of apparitions of origin. So certification marks and marks owned by the national governments, regulatory authorities may not be envisaged by this bill. We made comments and we are hoping that they are going to incorporate before presentation to Parliament. The next slide. A very important decision, democratization of agriculture and seed sharing. There was a constitutional petition filed in the High Court in Machakos. This was a court of first instance, and it declared sections of the Plant Varieties Act unconstitutional because it limited sharing of seeds that are not certified. It required any seeds for planting must be distributed by a regulated seed supplier, and they must be certified. In the African cultures, as the panelists will tell you here, food, cooking, and eating is a cultural ritual. Planting, the same. They share seeds from one person to another. There are people who do not know shops that sell the seeds they have eaten, the food they have eaten for the last 20, 30 years. So this decision sought to perpetuate that culture of democratizing seed sharing. The next decision. Coming on to challenges of prosecution, I would like to start with Uganda. Uganda in the East African region is our most progressive jurisdiction in terms of enactment of the laws. While Kenya, we are still administering the Trademarks Act of 1953 with the rules that were last amended in 2003. Uganda has the Trademarks Act of 2013, which even envisages registration of color marks and other non-conventional marks. But when it comes to enforcement, even in terms of refining the practice of trademark, it has been an issue because while they have very good laws, the institutions are very weak. The Registrar of Trademarks and the Registrar of other IP rights is still resident in the Registrar General's office, registers companies and all other forms of registrations. So specialization becomes very difficult, and that's why I think the law of trademarks has not grown from the practical sense in Uganda. Uganda also do not have a specific authority to enforce counterfeits. Unlike Kenya and Tanzania that has the Kenya Anti-Counterfeits Authority, Uganda do not have one. So it's very difficult even for the nationals of Kenya and Tanzania to coordinate the fight of counterfeits. On the other side, the East African region has a centralized customs management system. So it's very easy to communicate and track customs, especially when counterfeits are involved. But we have fairly developed in Kenya in terms of counterfeits enforcement, and we are also exporting some assistance to Uganda. So we have much of the disconnect we have been having is the market investigations. And we have now Kenyan investigators crossing the borders to Tanzania and even to Uganda. So should you have challenges fighting counterfeits in Uganda, you are able to have footwork through the Kenyan investigators. Registrar that I mentioned. Second, the next slide. So we would recommend, I think the first point for Uganda would be to demutualize the Office of the Registrar of Trademarks, the Registrar of Geographical Indications, with all the other registries. Again, Uganda is the only country in East Africa that has a Geographical Indications Act enacted in 2013. All the others, we are struggling. Kenya, we are second, still with a bill. Time is now ripe to have a specific authority to deal with the counterfeits. The next slide. The other challenges, even when we talk about oppositions, expungement proceedings, we have very good laws, as you could have seen in Uganda, and also in Kenya, being common law, we have far much developed the law even beyond what is in the statute. But the main difficulty is in the evidence gathering. You find many cases, including Sony, and again, we are going to see the Scotch Whisky Association versus Africa Spirits judgment coming up in June. Many of those cases are determined won or lost based on evidence. Did you provide evidence? Did the evidence have probative value? Or was it even competent evidence? Because you find many IP owners, they want to rummage through the internet, they collect evidence from all over, they don't take time to validate that evidence. So I would like to urge the IP owners and also agents, try to make effort, have liaisons with their lawyers on the ground to have proper evidence corrected. And we have enough machinery to correct evidence. IP investigators, there are many. We have many organizations to conduct market surveys. And the other difficulty when it comes to validation of evidence, sometimes we have to use the investigation arm, the police, and you cannot just walk to a police station and tell the police investigate. There must be a criminal complaint. And there are many IP owners do not want to go that route to pursue a criminal complaint. And then when evidence is gathered, you have to approach now the court under Section 14 of the Victims Protection Act, and you say, look, I'm a victim of this crime. It has been investigated. Can you avail me all the materials that the police have collected, which are materials they did not have the powers to collect? And then armed with that evidence, you have no reason to lose your case. The next slide. There are also reluctance of IP owners even to pursue judicial proceedings. There is a myth or a perception that we do not have effective laws in Africa or the East African region, or the law is uncertain, or the judiciary or the competent authorities do not understand IP rights. They do understand, and that's why I took time to create that background. I think we have not done enough to create awareness, and I'm very grateful to Professor and Johanna for organizing this panel to be able to tell the world that the law is very clear, and that's a common proverb in Kenya. The law is very clear, and all we need is for you to come armed with evidence, get the right lawyer to guide you on the processes and the steps to take. You should be able to win your case. And even the Sky-Click decision on good faith by the Supreme Court of the United Kingdom, the Kenyan courts are waiting to be able to enforce foreign marks under the good faith principle. They're ready, but you need to get your evidence right. The next slide.
Nope.
Oh, that's the end.
That's it.
Like all our African presidents, allow me to go off script. We do not trust our speechwriters many a times. Just a few comments on the challenges we are facing. We've talked about the evidentiary challenges. The other challenges that I think this is what has been most frustrating, especially for Kenya, is the timelines for prosecuting matters, even prosecuting trademarks, and even enforcement. You find if you have a trademark, once you apply for a trademark registration, the advertisement period is 60 days. You have to wait for 60 days, nothing happens for any person to come up and oppose that mark. If someone files an opposition and they have an opportunity to extend that period up to 90 days without giving any reasons, they only need to say, I had not gotten a counsel, give me 90 more days. So from 60 to another 90, you're looking at about 150 days. After that, when they file the originating complaint, they have 45 days to receive a response. So the other party may again decide they don't want to respond within 45 days, and they can actually extend for another 90 days. After they eventually file, after the 90th day, they can decide you have the right to file a rejoinder within 30 days. Again, you also have an opportunity to extend the time for another 90 days. I think looking at the trademark rules of 2003, so much water has passed under the bridge. 23 years later, I think we need to relook into those rules of practice. There is no provision for mediation or other alternative dispute resolution. And for that reason, even where the trademark registrar or the examiners find a reason to encourage parties to try and settle the matter, they cannot propose. Again, Kenya is an adversarial system. An arbiter cannot be seen to be descending to the arena. So they cannot even make a proposal. So I think, again, we need to try and institute the procedure towards alternative dispute resolution. The other big problem we have had in our registries, and this is now really institutional, it's understaffing. And for instance, for Kenya, I've been a board member of KIPI, and I know one of the things we dealt with was staffing. We have had staffs who were employed in 1994. All of them are about to retire, about 60% of them. Hiring is very slow. And looking at the technical nature of these particular subjects for especially the examiners, it requires some period to train. So they are a bit slow. But then again, when you look at an establishment that has an organogram requiring 185 staffs, KIPI is currently operating at 68 members. When you have 68 versus 185, that's a huge deficit, and processes are about to be slow. To try and hasten this process, Kenya Industrial Property Office, they've tried to, in a sense, automate some of the procedures. Once your trademark is examined, there's now no requirement of human assistance to take it to the journal. It is axiomatically populated into the journal. And every first Monday of the subsequent month, the journal is published online automatically. It doesn't require to wait. In June this year, with the assistance of WIPO, Kenya Industrial Property Office is looking to roll out online filing system. We already rolled out a patent filing system. It was launched in March this year. And by June, we'll have one. We are very grateful to WIPO for what it is doing to try and revolutionize the IP office. I do not know what will be the place of AI in automating that office. We'll have that conversation at another forum.
Well, thank you for that seamless segue to WIPO as well. That was really good. David, actually, I do want to turn to you. So the African Continental Free Trade Area is a potentially significant example of multilateral cooperation, but there are attending challenges and opportunities with that cooperation, as indeed there have been with previous attempts at sort of similar sorts of strategies and initiatives. We'd be really grateful for your expertise on those kinds of challenges from that multilateral perspective and the ways in which WIPO can also assist moving forward, as we've already opened with.
Okay, I have to say I found the whole session very interesting to listen to all these different perspectives, and I'm very grateful for the organizers to invite us. I've been in WIPO for 30 years, so I have really seen a lot of things. And each country has to decide what it wants. And when my sense is that more and more countries, also in Africa, are now much more thinking about how to use IP for their own benefit. It's no longer, oh, the foreigners with IP, it's a bad thing. We want fair use. We want exceptions. There's been a shift, certainly in the last 10 years, I would say, where many more countries realize that if you can use it for yourself, you will benefit for it. There's no need to be against IP. Now, one of the big challenges, and this is not just in Africa, but also in other countries, is that depending in a government who has the greater weight, one perspective is more dominant than the other. For instance, there is a big country in Asia, I won't mention the name, and there's a clear distinction between the philosophy of people in the foreign ministry, who are much more into, I would say, almost an ideological view about the Western world and the developing countries, and who will still approach the IP system almost with, well, not almost, with a great deal of skepticism, and will always emphasize the exceptions part and the fair use part. But then another ministry that's more business oriented will look at it very differently. So you have these different philosophies in a single country, and my real experience is if the country does not manage to come up with a clear view of where it wants to go and maintain that clear view over decades, you're going to lose a heck of a lot of time arguing about things that may or may not matter that much. So it's extremely important for any country, and that not just Africa, any country, to know, to have a strategy. What do you want to use the IP system for? Do you have industry or companies that could benefit from it? The long-term trend clearly is that more and more countries and companies can actually make active use of it. It's more and more stuff is about branding and digital, and that's very, very close to the IP system. So the opportunity to make use of the IP system is there. And then the question is, I always say, I try to say this, as a government policymaker, try to approach the IP system first and foremost from an engineering perspective rather than a legal perspective. What do I mean by that? It must work in practice. You can sit and argue for decades whether, you know, Sony should be or should not be a well-known mark in a country recognized as a well-known mark. You can argue for decades whether a color should be protectable or not. These are important and interesting discussions, but the most fundamental thing is that the whole ecosystem has to function practically. It has to work. And for it to be able to work, there are separate components that have to work. As lawyers, we think mostly of the legislation. That's a very, very important component that has to be in place. But I agree with the speaker that in many countries, that's really not the issue anymore. So the legislation is important. The functioning of the IP office. This is a big problem in many countries. The practical functioning of the IP office. We know, and Africa is a big continent, many, many different countries. Some countries function really well. The Kenyan office, the Moroccan office is known to be a well-functioning office, but we heard about the Libyan office, and there are other offices like that that really don't function. So the IP office has to function. The police, the customs authorities have to be aware of the importance of IP and have to be sensitive to it. The courts, the judges need to be sufficiently knowledgeable about IP to make the system function. And the businesses, especially the smaller companies, need to be sensitized to how they can profit, how they can benefit from the IP system themselves. So these different parts have to be, I would say, minimally in sync. If one of the parts is out of whack, the system will not function well. And I think the main challenge is to have a consistent government policy that stimulates the development of all these parts in sync. And it's our job to assist the countries to do that. So in the past, we spent a lot of time on legislation. Now that's still sometimes an issue, but if you look at the amount of time we spend on legislation compared to 20 years ago, it's almost nothing. Then there was another stage where we really had to build up the IP offices. That's also much improved, but it's still quite patchy. Enforcement, police, we are spending more and more time on that now. So and also sensitizing business. So WIPO has a whole range. I can't get into the details, but we cover all these elements, and we consider it our duty, our job. It's really our mandate to help countries develop that. And that's why a final thing I would like to say, I was extraordinarily impressed by the minister this morning, because yeah, well, I would appreciate that, but I really was, because she talked about the IP system almost like a business person, and you know, without any I would say hesitation or defensiveness in saying what needs to be improved. And we need those types of leaders to really make progress. So that's my sort of input on this. Thank you.
I think that actually takes us very well into, I mean, I know we've touched on enforcement throughout the discussions, but it takes us very well into the enforcement environment, which is of course incredibly complex in a multi-jurisdictional environment. Pascal, you've mentioned previously when we discussed about the interactions between enforcement and brand protection. Oh, sorry. Yes. Yeah, I'm hoping, Desire, that you will be able to bring all of this together, because the perspective from the Secretariat is really important. But I wonder if we might just very quickly from the panel, your key points about enforcement in your particular jurisdiction, if you can sum up the key issues for your jurisdiction.
Yes, let's start by Morocco. In Morocco, we have really a very good system, judicial system, where the tribunals are really very fast in issuing decisions. Like in terms of interim injunctions, they are done by weeks, and the actions in the merits in few months. Of course, you have three levels, the appeal and the cassation. And usually the criminal actions are not that, because the enforcement authorities are reluctant probably to act. So it's always easier to go into the civil route. Even at the customs, we go into civil actions. And I can say that we have probably more than 1,500 action per year between brand protection, infringement, unfair competition. And just a small issue which applies to all jurisdictions, we try as much as possible to proceed with a trademark infringement action instead of unfair competition. So this is why we always suggest to client to go to a trade dress registration of a trademark, trademark registration of the trade dress, instead of going into unfair competition, which is a bit complicated. Same for copyright. So it's always better to go into a trademark infringement and or a design infringement action. So this is for Morocco. Same applies to Tunisia. It's not as fast as in Morocco. And by the way, in all these countries, we don't have an IP specialized court. It's like the commercial court, which rules. The judges are more and more IP oriented, and they have the knowledge in IP. They know about the systems, and they know about Madrid protocol. They know about designated countries. So it's much more developed since the 90s, let's say. For Egypt, we have a unit that can act on behalf for any complaint where you can go to criminal action instead of civil action. By the way, I missed saying this, and which will apply to all the jurisdictions in North Africa with a francophone, like Morocco, Tunisia, and Algeria, will go with a seizure, a descriptive seizure, or a seizure in itself by a bailiff. And within 30 days, you will have to act against the adverse party or the citing premise based on this seizure. So back to Egypt, it's we have this unit which we can do seizures and can, based on it, assign an expert to do assessment of the infringement, and then the proceeding goes into a criminal. While if we go through a bailiff, it's like it takes long time and it can take for years. And this is you have the bailiff seizure and then an expert who assess the trademark infringement, and he needs to go to correspond with the trademark office to confirm the infringement before giving his report. Finally, and to close North Africa, I believe for Algeria, we have like 30 days to, it's a requirement to try to proceed to a mediation. And based on it, if no result or no resolution has been done, the plaintiff can proceed to the action in the merits. And it's always like a bailiff, seizure, descriptive or not descriptive, and then action in the merits. Thank you so much.
Thank you. And so Femi, effective enforcement in Nigeria, does it need systemic reform? Is it a systemic problem?
Let me start by saying that one major problem that may affect enforcing your trademarks is issue of search that starts with prosecution. We have a very weak search system. I'll give an example. We have a case that we are doing right now. The trademark registration has been done since 1991. Because of defective search system, an infringer was able to register the same mark in Nigeria. Because of that, our clients have had to spend thousands of dollars to enforce in court.
Yeah.
At first, we compel them to transfer those marks to us by settlement. The same infringer went back to the registry to register. And the application was approved. Thank God for opposition. Yes, there is an alert, international alert, and we are opposing the registration of that same mark that we have been in court for several years for, that they have transferred. The illegal marks were transferred to us. Yeah. The same person went back to court, to the registry, with the intention to register the mark. So we start from there. If you register your mark and your trademark is valid and subsisting, the Federal High Court will give you what you want in terms of injunctions and damages. Our courts are ready. In terms of police, I cannot say much about that. In terms of customs, we have used a custom raid before. We raided that factory, but the result only lasted 24 hours because the owner, the infringer, was a very, very powerful man in Nigeria. With one phone call, they returned everything that we raided. So, but thank God, it was a society case. They had registration. subsistent trademark registration. So we went to court. We obtained an order. We went back to the place and closed the business. Up to today, that business is closed. So in Nigeria, the best option is to have your mark registered, a trademark registry, follow it up, ensure that it's valid and consistent. You do all that you need to do. If you go to court and present your case very well, you will get injunctions, you will get every damages. Our judges are trained, they are prepared. And thank God, thank you, WIPO, for the training you're doing.
That's a very good point, actually. I mean, it's what we were talking about earlier when we were talking about prosecution, is this relationship between prosecution and enforcement. And if you have this ineffective prosecution environment, you're actually creating disputes.
That's right.
And that's a really good example of exactly that. John, you know, similar sort of uncertainty around the enforcement environment in Cameroon. I mean, what are the major issues? Is it substantive law? Is it procedural? Is it, you know, is it administrative? Is it everything? Is a potentially unified market a strategy for reform?
Thank you. You mentioned Cameroon. I think it's we're looking at OAPI. Cameroon is just one of the countries in the OAPI region. And I think the issues we face, the challenges we face are purely systematic. Because you're dealing with 17 countries, 17 different systems. Now, the OAPI as a structure doesn't have a unified set of rules that governs prosecuting or enforcing judgments, because there's the understanding that there's going to be a different set of rules for every country. So whereas OAPI may issue decisions pertaining to cancellations, to oppositions, and all of that, strictly speaking, enforcement has to be at the local level. Now you have countries with a more sophisticated judicial systems, with looking at Senegal, Ivory Coast, Cameroon. You have other nations where, for lack of use of a better word, it's a jungle, you know. I don't want to call names, but it's difficult, particularly difficult having to navigate, you know, those abstract jurisdictions. But the advice we always give is to always align with proper and legal counsel. Because, and as my senior here said, sometimes the authorities are complicit in ensuring or making it possible that, you know, these rules are not enforced or they're not applied. It's also important to create that awareness. Believe it or not, you know, if some customs officers or some custom structures don't even understand certain concepts, certain IP concepts. You know, there are certain countries like Cameroon where we do seminars, trainings, symposiums like this to educate them on exactly, you know, what are counterfeit goods, what is the contraband, what is an infringement. And in a way, that awareness kind of, as time goes on, it elaborates and improves on these structures or these mechanisms in place. So I would say, locally speaking, you know, the possibility of enforcing will largely depend on the jurisdiction in which you are dealing. But I would say it's pretty systematic. And with OAPI, there is this continuous initiative to improve and to educate and to create that awareness so that the rights of IP owners are better protected within the OAP region.
And that's such an important point about expertise, also with customs and border officials, and it's such a difficult area.
Absolutely.
And it is such an area of vulnerability when it comes to enforcement. Mwenge, you spoke about famous marks in your presentation as well. How difficult and unpredictable is the enforcement environment, particularly for famous marks, since you've introduced them earlier? It'd be interesting to hear a little bit more on that question in Kenya.
Thank you. I think the starting point is how the mark is registered. How you prosecute the trademark for your client matters a lot, because when there is a gray area as to whether the mark that is registered is what is actually in the market, then it enlarges and widens the gap of settling any dispute or even confiscating any counterfeits. So it is very important that you register your trademark in Kenya in the manner that that mark shall appear in the market. If possible, you include the colors and all the get-ups. Then after that, you need to conduct a personal search. And a personal search in Kenya, this is also one of the efficiencies we pride in Kenya. A personal search can take at most 15 minutes, and you only pay $50 or $100. And once you conduct the personal search, keep a copy, then obtain a certificate for use in legal proceedings. Your certificate of registration of a trademark has no value for legal proceedings in Kenya. So you need to apply for a certificate for use in legal proceedings. Arm your client with those two documents. They will be able to fight counterfeits in the market. One of the challenges we are having in fighting counterfeits is that we have an online system for recordation of marks with the Anti-Counterfeit Authority. But that system is on and off. It's on and off. But Kenyans have applied the Nigerian proverb that when hunters know how to shoot without missing, the birds learn to fly without perching. So what the Kenyans have done, and we have many brand agents, including lawyers like all my firm, attorneys, we have a huge WhatsApp group that has police officers, enforcement officers, lawyers, brand owners, brand agents. And once a brand counterfeit is nabbed anywhere in the country, it's posted there. Who is the agent for this brand? Or if you have a brand that is being counterfeited, you only need to tell the police that we have found this brand in the market. We do not know at what point it's entering the market. Kindly seek this brand. The anti-counterfeit enforcers are police officers, and then we have the formal criminal investigation officers. They are easily reachable on that platform. This is an informal system. What makes it, again, more easier to enforce? In many countries, and especially Uganda, the difficulty of enforcing counterfeit is once you confiscate the counterfeit materials, where will you keep them? A whole container of counterfeiting materials. In Kenya, the director of Anti-Counterfeit Authority has the power to act suo motu. So long as you complain, even as a foreigner, you don't need an agent. So long as you complain, you produce evidence, and it's compelling that you have the genuine mark. They can act suo motu, and they confiscate the offending merchandise, and they keep them in warehouse. They have huge square feet of warehouses around major towns, including in Nairobi. And through Anton-Pira orders, even your clients, if they have go downs, they can ask for Anton-Pira orders, and courts are very they are very keen to give Anton-Pira orders. You can confiscate the materials, and you keep the materials. If, as I said, the mark in the market is the same as the one on the register, the dispute is almost immediately settled, because the executive director also has the powers to compound the offense. Tell the infringer that you're infringing these marks. If you don't have any other mark or any other reason to justify why you're using this mark, we should be able to pay the fine, or otherwise the indemnity will be higher. So we do not have much of a problem in enforcement or a gap in enforcement. And where the system has a gap, the Kenyans have found a way of going around it. When my friend was talking about the many cases of one person continuously infringing, He reminded me of a gentleman called Harris here in Kenya, in UK, in the case of Harris versus DPP, where he used to sell flowers at an unauthorized cemetery. And he had received 210 fines, and the wife had received 94 fines until now they had to be injected. And that case kept playing in my mind. I don't think we have had such cases in Kenya where a person is trying to test authorities. Again, registries are watertight. True, the company's registry and the trademarks registry are not connected, but there is no way you will be able to register a mark a second time simply because the search could not capture it. But then again, it boils down to how you prosecute your trademark. Thank you.
Thank you. I'm really keen to hear from Martins, because of course Martins is Director of Enforcement, but we also want to leave enough time for Desire to bring together these to give us a Secretariat perspective on these issues around prosecution and the challenges of a unified market. So Martins, if one thing I would be interested in, because just earlier in the discussion we've considered this, but do we need to pay more attention to we talk about enforcement as an owner's issue, but also thinking about enforcement, effective enforcement as a consumer issue?
Well, I will say that our approach in Nigeria, at least from my own standpoint where I lead enforcement, we do it from consumers' issue perspective. Because if you have a product that is a counterfeit product, it's a consumer problem. And for you to want to go the route and remove them, deal with the issue without owning the brand yourself, we see it as an opportunity to defraud the people, and so we enforce. So we don't actually need to wait, and this is what I want to say, and I will cite examples. We actually don't wait till there is an IP office contact us and say there's an infringement on this brand. We don't wait. We have in 2023, like part of the things that we read there, we entered a market called Eziokwu market, also called cemetery market. For people from the Southeast, they will understand there. In Aba, yes. That place, nobody has entered there before. Nobody, because it has become a crime scene, because the people are sophisticated. They have so people in the hall can relate with what I'm talking about. Sophisticated, even non-law enforcement person can easily walk in there and come out. And so what we found out that they do is that we discovered, I led the operation, we discovered over 250 manufacturers in an enclave. And what they are doing is copying everybody's brand. Over 250. And so you imagine, so every day they load out tons and tons and tons of products that a lot of the market authorization holders are declaring losses because they've taken over the market share. They cannot make sales, and they don't understand why they cannot make sales. And this is very delicate and somehow, because you will not know the difference. So this one is different from somebody trying to, they know. It's not as if they just want to pass off. They will do the product for product, they clone. In fact, they even use the owner's address. They use the owner's address, use everything. So sometimes some of the owners don't know the difference. Their product and the counterfeit. And I think I've seen this live, so where we have owners, I don't want to mention brands, came to the office and were almost weeping. That we didn't know why our market share was dropping. We just knew that the product was everywhere, but yet money is not coming to us. So we see the product everywhere. So we didn't, that operation, we didn't wait for a complaint because this was a large scale infringement going on everywhere. And we see that as a consumer issue because the total number of brands of the product that we saw that were being counterfeited were over 50. So it's no longer a brand owner making complaint and all of that. We dislodged them, we arrested, we did prosecution. The prosecution is very, very strenuous. It's strenuous for us because you have to give enough evidence, you have to give all of those. But we're able to get through all of that. So to your question, we are seeing it not just only as, personally, I prioritize consumer safety over even IP complaint because we don't have to wait till there is a complaint. If we notice something is already in the market and it's not what it's supposed to be, it's our right to take it off the market and remove it. So that's what we do. And we did this repeatedly again when we did the operation we did in Onitsha last year, where we moved out over 140-foot trailers of fake and counterfeit products from the market. It wasn't a consumer complaint, and the number of brands that were affected were over 100. So because almost everything were being made there. Some of them were manufactured in that same premises where these things were gotten. So we work on intelligence and we work with security agencies. In my position as the chairman of anti-counterfeiting for food and drugs in Nigeria, I have police as members, I have the military, I have the customs, I have the consumer protection unit, FCCPC. I have them in that. So we meet constantly, we review, and when we see a need to take action, we do not wait. But I must also say that it is very, very capital intensive. It is. I think it's one of the reasons why it's quite difficult in our jurisdiction, because I know how much the agency spent for that operation last year to get it to where it is. I know how much the agency spent to get it to where it is right now. But from time to time, every day, these are things we come across and we move them, not until. So when we have law firms writing us, brand owners, so that one, to me, what we are doing now, that is like 20% of the operation we carry out, because we do not wait until you make complaints before we go out and remove offending products. So we are looking at it from safety aspect and consumer aspect, and that's been able to help us. If not, we have to wait for IP owners to write us. Then
I think that's what's really interesting. I mean, it does take us to that question of the importance of the market. So we've been thinking about, if we address the structure of the market, does that give opportunities for reform in other areas? I think it's a really good explanation of that perspective, because when you're looking at that consumer relationship, you're looking at the market. So perhaps at that point we can have, if Desire, you've been very patient, and I hope you've enjoyed this insight from the different jurisdictions, different perspectives. We would be very grateful at this point for the Secretariat view on these questions around prosecution and enforcement, if you are there. I know, but is he actually there? I can't unmute him. I haven't seen him the whole time, Bankole, because he's had so. Oh wait, we're unmuted, I think.
Okay. Thank you for.
Thank you so much.
Thank you for the floor. And then, unfortunately, I have to run shortly in another meeting due to the time schedule that you provided to us. So just basically to say that I think the discussion has been pointing out what is happening on the continent. The fragmentation of the various regimes with the impact on the prosecution process and the enforcement procedures as well. All these are part of the fragmented aspect that as the Secretariat, as the FCFTA, we would like to address by bringing our state parties together in finding a way of having one, same rules and principles. Secondly, operate them more or less similarly. So many of these discrepancies emanate not from the text of the laws or regulations, but from how they are perceived and how they are used. So in this regard, the main gap that we have identified in this way are the practices. The practices differs from one country to another, although they are all part to the same instrument, with the same principle, the same obligations. But now, the capacity, the competence, the expertise of those in charge of the application now creates like a differentiation, create like a gap. I think this is an area where we have identified there is a serious gap that we need to address. When it comes to the FCFT, let me just give a quick background to say that as it stands now, after the adoption of the protocol in 2023, and then the adoption of the 8 annexes in 2025 last year, we more or less have the FCFT IP ecosystem in place. We are just missing the annex on the IP office that will be discussed this year. So with those elements, the agreement from the state parties are to have a continental IP regime to align their practices, to align their regulation. Based on that, we are envisaging to monitor how these gaps will be bridged. So technical assistance will be provided in this regard, and we will do that, of course, in partnership with all the institutions. But the most important was for us, as I mentioned already in my introductory remarks, is to address the convergences that may assist in aligning the IP regime with the trade regime, because our IP regime, as you know, is from a trade perspective. So how do we make sure that the trade regime that is already developed, well advanced now in terms of policy, is also supported by a comprehensive IP regime? That's the mission that we are having, and that's what we are working towards. Hopefully, we'll make it happen. When it comes to prosecution, as I said, when you go to the laws and regulation of Cameroon, Kenya, Nigeria, Morocco, all the countries seated there in the panel, you will find more or less the same processes. But when it comes to the application, that's where problem starts. And I really appreciate the way the director of the enforcement in Nigeria put it. Because yes, you have to one approach that is practical, that is contextualized, that helps you to deal with the same issue, but in the specific context. Because the laws sometimes are very good. I remember we had a discussion with the Americans. They were telling us, why do you want to have new instrument? You already have these international instruments, just as your countries to adhere to them and then enforce them, full stop. But you see, even with those that already exist, the Bangui Agreement, as my compatriot Barrister Hale mentioned, or my colleagues from Nigeria and Kenya, they are more or less the same. So this issue of practices are important to tackle. When you come to the grounds of infringement
the acts prohibited, all these elements. Some of them are contextualized, but generally the philosophy is the same. Is to provide more security to the right holder, is to secure the consumer, is to give more services to the user. So those kind of elements are important to address. And we believe that this is an area where the AFCAT will be very important. I don't want to repeat what has been said because of the short time that I have. So let me just stop here. Maybe in the next session, where we'll be given more time, we can elaborate more on what we are doing. There's a lot of initiative that is on the ground now from our side to address each by each. I think my colleague from WIPO elaborated on how it should operate. Think about it as an ecosystem. If you think about it as an ecosystem, what are the pieces of the puzzle that you need, and how do you make them work together? So that's exactly the methodology that we are having through the different two big projects that we are developing now for our state parties. Let me stop there for now.
Thank you so much, Desire. I think that that's such an important point, looking at changes to behaviors and changes to practices. And perhaps if I could ask you a question, to what extent do you think the market is really a signal to that, a single market, a unified approach? It actually is a signal to change behavior without the kinds of systemic changes or substantive changes, I mean to say, to the law. What you're describing, I think, is a really compelling argument for the way in which you build trade relations through those contexts.
So the principle of the single market, specifically the one of the FCAT, lies on the Abuja Treaty. What we are looking for is really the African Economic Community, which means at the end of the day, we have a common market, a common union, a unitary market, by the way. So we are still far from that, but that's the target. So how do we start it? We started by the free trade era, which is the current status that we are now. But maybe in the next 1 or 2 years, we are moving to the common market, because all the pillars of the common market are already in place, including with the intellectual property system. So this unified market requires us to have rules and principles that are aligned. Just to highlight it, when you take the trade regime with the rules of origin, that eases the movement of goods and services across the continent. Let's try to apply it to an IIPR to see what the gaps could be and the effect and the impact could be. You have my colleague from Kenya who is exporting tea on a specific brand to Cameroon because they are neighbor there in the room. So the shipment will leave Kenya. The brand is there, is registered, that's fine. And then at the entry point in Cameroon, there is someone there coming to the custom saying, no, this brand of tea, I own the property here in Cameroon. I have never authorized it to enter here. So this is where the gap between intellectual property and the trade regime can affect the unification of the principle that we are having. You see, that shipment will have two options, either to go back, either to be seized and destroyed, full stop. There will be a third option. So this is where the alignment is important. And one way of aligning it is to have like a common rules. When it comes to prosecution, and again, I think it's been said there, enforcement lies in majority in national laws, on national laws. But then you have to agree on principle of what those national laws need to have so that you have more or less the same at the continental level. And this is the exercise our member states have agreed to move on. In terms of customer administration, you have to have one instrument that guides how they operate, for instance, border measures, so that there is no discrepancies on how the same border measures is enforced differently in Nigeria, in Kenya, and so on and so on. Kenya just indicated that they have an enforcement authority, for instance. We need to take it as a best practice. This is a best practice that we can populate across the continent so that when we have Kenya, we can go around with Kenya to say, okay, please spread this message to show the benefit of having an anti-counterfeit authority so that other countries can do the same. And then we have a group of anti-counterfeit authority that we speak the same language, that we apply the same practices. So that's how it operates. This is valid for the IP practitioners. Kenya IP lawyers have good on this. Cameroonian IP lawyers, how can they share so that they have more or less the same practices when it comes to the FCFT IP ecosystem? Valid for the judges. You see, grants, absolute grant, the way the Moroccan judges are examining them may differ because of the personal expertise, the personal understanding from how South Africans are doing that. Sharing this knowledge, sharing this expertise will help to address the gaps. So this is why we have developed this massive program on AFCFT IP convergence of practices to address this kind of instrument, so that when the market is developed, the measures accompanying, the measures supporting, including IP measures, also are developed to support the continental market in a unified or in a harmonized approach. Thank you very much.
I think that's such an important point, and it's such a compelling way to illustrate the way in which trade is also this sort of cultural event, if you like, and IP is a part of that. And I mean that's why I think that this whole panel has been so interesting, and I completely agree. I think we could have had a whole day, Bankole, because it's just been such a fascinating discussion. I realize you have to get away, Desire, but I just want to congratulate you and you know, on the immense amount of work and the tremendous achievement in bringing this to fruition. And thank you so much for giving us your insight today and your responses to the panel. I think we're all incredibly grateful. So thank you so much.
Thank you, Professor. Thank you, Professor Gibson. Yeah.
Bankole, would you like to make some comments? We've worn out the microphone.
Yeah. So first, André du Plessis from South Africa couldn't come because he had a health challenge. He couldn't even fly. And I begged him whether he could join us virtually, but he wasn't able to. So it's not that we use his trademark or brand to bring you here. I want to say a very big thank you first to Joe, Professor Johanna Gibson, the Herchel Smith professor at QMUL for agreeing to do this. What I didn't tell her was that I actually reached out to Sir Robin Jacob, whom I had sat with, say, look, you've been talking about things over the years. Would like to do this, and he said he won't be in town. He doesn't know whether anybody will have time. And I reached out to Joe, and here we are. So please give her a round of applause for allowing this.
I will be mad about second choice, but it is Robin.
You know, because I mean, this is home for me. I was here 91 to 95 for my PhD, and it's so nostalgic. Although we're not here then, we're in Mile End, but I recall that even in those days, we're always running programs, and so it's fantastic. And then I want to thank the panelists whom I reached out to and dragged. You know, to come and pursue them, and they're all tired. They've had meetings and meetings in the last few days, and they still oblige us in coming, and also to the audience, some people who are online and those who are physically here for attending. I hope we've been able to meet some of the things we suggested we would. And we're going to have interactions afterwards through the generosity of Joe. We have a lunch, and although there is no jollof rice there, but you enjoy yourself and mix with other people. So I think we've been very fortunate that the minister could join us because she wanted to be here physically, but she had to be away. I think she's in Spain or something. But a lot of perspectives, and we'll be working with the regulators, work with Kumeri to see whether we could push this forward in terms of, particularly with the AFC Secretariat, see whether things can actually improve. So thank you very much.
And with that, it's definitely time for lunch. I think we should take questions over lunch.
Okay, photograph.
But what I would say, thank you, Bankole, thank you to all of the speakers, thank you to the audience. It's been a fantastic day. And